Hey, everybody, and welcome back to the Legal Weekly Wine, where we discuss the week's hottest legal topics. We are into June of 2024, and this week we are going to be discussing the ramifications, what's happening now that Trump has been convicted in the New York fraud case. And then we're going to talk about Hunter Biden today. That is also the big legal news, is we've got the Hunter Biden trial for firearms offenses. We're going to talk about both of those things. We're going to divide it up between those two things so we can finish up at least the portion of the Trump trial and then come back to it for actual sentencing and then start with Hunter Biden today. I'm Virginia Tarani. I am the CEO of the Law Unscripted, as well as the attorney owner of Tarani Law LLC, because you never need a lawyer. Tell you do. We offer, for the Law Unscripted, we offer bar review and law review classes, law school exam classes, mostly as a supplemental where you can choose one or all of your core 8 subjects for bar examination studies. So if you're only having trouble with evidence or only property, which I would have, then you can pick and choose as you would like, including outlines for the classes, or you can choose the entire program. So find that on thelawunscripted.com. Along with these podcasts. The Law Unscripted hosts the Legal Weekly Wine, and we provide that as a free resource for anyone on the website. And mostly, we hope law school students are really engaging with us and finding it useful. Attorneys, and honestly, most of the public. We're having a really good time filling everybody in. And I am joined today by my co-host, who is also our partnership with Tarani Law and the Law Unscripted, Chelsea Rogers. It is good to have you back.
Hey, glad to be here.
Yeah, thrilled. We've got 2 attorneys here, right? 2 similar opinions on a lot of things because it's the law, right? We're both trained in the law. We both have a lot of the legal experience and background, but we also have our different personal opinions.
Absolutely.
Sadly, this week, we are missing Dr. John Vial. He is the Dean of the Honors College at Middle Tennessee State University. He is out on vacation this week. Everyone deserves one. Glad that he is doing that.
Very jealous, actually, of his vacation.
They're on the Danube River. I mean, how can you complain about going to Austria and Germany? And it's a lovely trip. I've heard wonderful things. We wish him and his wife, Linda Vial, the very best at that. We're looking forward to having him back for the start of the big Supreme Court summer session, right? So this is going to conclude our current season. This is going to be the last one in our season. We're not going to stop there. We're going to pick up next week. It'll just be officially a new season for whatever that's worth. We're going to start covering the Supreme Court session. We are really anticipating the privileged immunity, the presidential immunity case that is being considered for Trump's other criminal case as to what does he have immunity for during his presidency. Anyway, we digress. We're going to get back onto the topic of what happens now that Trump's been convicted. We're going to do a quick recap, then talk about the implications, and then talk about Hunter Biden.
Yeah.
Woo. That's
super easy, super chill, not too much controversy, really easy to cover today.
Yeah. Goodness. What do we really have to talk about? We're all agreed, right?
Yeah, exactly. Yeah, super easy. Not too much discussion to be had there. What are you drinking, Virginia?
Okay, so I am still on the issue of, and I keep saying this is like 3 weeks in a row where I haven't had wine. And it's really ridiculous because I keep saying, I've got to go buy some more wine. And then I keep forgetting, which you would anyway. So today I have what would have been considered like a wine cooler back in my day growing up because they were all the rage.
Okay, wait, I haven't seen it. Let me take a guess.
Okay, you want to take a guess? It's not an actual wine cooler.
Okay. Oh, okay. Okay, I feel like, because I can see it's a bottle. Yes. So I'm going to go either it's Seagram's or Mike's Hard Lemonade. One of those two.
You're
Am I right?
So close. It's very close. It's going to be the Jack Daniel's Watermelon Punch. So it's very similar. So that's what it is, right? But it's like a Mike's Hard Lemonade. And
I love that.
You and I have done many times, we love the watermelon flavor. It's such a summer flavor. I don't love watermelon, but I love the watermelon flavor. So that's what we've got today. What about you? I see some, is it Moscato?
No, it's not today. Okay, it's not.
I see. We're back. White.
It is. We're back at it with the Aldi finds. Our winking owl boxed wine, very classy right here. So it's a Pinot Grigio.
Wonderful.
Which I've been trying to expand my palate. I can't just drink, Moscato all the time. So this is fine. I drank a lot of Chardonnay the other day, and that was not for me. It was not my wine choice. And I drank it, and I was like, this is not for me, but I could do the Pinot Grigio. I can work with that.
It's less dry. I find Chardonnay very dry.
Yes.
Which is not my favorite taste palette
No.
flavor there. My wonderful, wine connoisseur self saying wonderful words that everyone's cringing at. But anyway, thanks for that. Cheers to summer and Trump and Biden.
It's like 2016, but worse.
Right. Okay, so thank you for those of you who are commenting on our podcast. We received a couple of really great comments in the last few weeks, and I want to read off a few as we go along because we want to acknowledge some of them and answer some of the questions. So we had, and I swear these are relevant. So we had, let's see, Adam-FQ2DM, for whatever it's worth. He said that he'd love to see a summary of the charges and verdict before jumping into the detail.
Yes.
I appreciate that comment. So what we're going to start with is a very quick recap of what Trump was convicted of, in which court, and why it's even going to matter. Chelsea, how many charges did he have?
34.
Yes. Do you remember why it's 34?
Okay. Yes. And everyone's going to laugh because I know my math is off already. But from what I remember, because I know I have to be missing one somewhere. What I remember, there were 11 different instances that each had 3 charges, which I understand.
Correct.
11 times 3 is 33. And we're missing one somewhere.
Where's the 34? Yeah.
I don't know.
So, and this is back, I encourage everybody, with Chelsea and I in episode number 16, it's been forever ago. That's how long this case has been going on. This is episode like 68 or 69. So episode 16 was entitled, oh heavens, The Stormy Daniels Hush Money Case Explained. Go back to that one. Take a longer listen to that. We go into full detail breaking down, but it is hard to remember after all this time. So
I think that was the only episode I've actually written notes for. I annotated because I printed out the actual copy of the indictment and had all of my notes on it. So if you want to see me fumbling with notes, that's the episode to look for.
One out. Yeah, and it's still playing in my background here. I'm going to try to pause that. Yeah, check that out. And you're right. It was 3 times 11. So there were 11 months where there were 3 different transactions.
Oh, is the last one the election one? Okay, see, I knew.
It was the December. So the last one was the December, and it was only one part of the transaction instead of 3. So there was the approval, there was the presentation of the check or the request for funds. There was authority for the funds that were given, and then there was the check actually written on the funds that were then given to Michael Cohen. So each one of those is considered a business document, a business record. Yes. And under New York law, New York state law, in addition to many other states, you can't lie on a business record. Your business record. It's sometimes considered, it's interesting because it technically could possibly be a federal IRS claim, right?
That's what I'm saying. But I think that's interesting is that when we have, and I'll throw it out here, Civ Pro is not my strength, civil procedure here, but that's what we're talking about is jurisdictions, is this was a state law offense.
And why does that matter?
Matters for a couple reasons. Biden has nothing to do with this. This has nothing to do with the federal government. It is laws enacted by, New York State, which are different. I live in Georgia. You're in Maryland. Every state has different laws. So it's a crime in that state. And what that also means is that he has been convicted. If that conviction is not overturned, he cannot be pardoned for this crime.
Not federally, at least not by a new president.
Sorry, let me clarify. Yes. So in theory, if he were to become president, he could not pardon himself. And Joe Biden could also not pardon him for this crime federally.
Or even another Republican, president, a subsequent Republican president. And that's another great question. I want to comment on that one as well, is we had Michael Sharp Michael Sharp, 4217. Let's assume Trump is reelected this year, pardons himself, and the Supreme Court says that a president pardoning himself is not allowed. Could he at some point resign, then the new president legally pardon him? And you're answering that question is because this is not a federal jurisdiction, then he can't be pardoned by any president, including himself.
Correct. And I think we can play a hypothetical here. We haven't done that in a hot second.
Let's do it.
Let's do it for fun. Okay, so if we assume that this was not a state law offense, let's assume it is a federal offense, which a president would then be able to pardon for.
Jack Smith's case. We've got two federal claims. We've got two state, New York and Georgia, and two federal.
Yes.
So he's convicted on a federal one of Jack Smith's case. Then what?
Sure, he gets convicted on a federal and he is reelected in our hypothetical here. Now that Supreme Court decision, I would be chomping at the bit to see how they would break that down because we have no precedent. We have no case law for it. So it really just comes down to the vibes of the Constitution and how the justices are feeling that day. I mean, that's the truth. They just have to go. They don't have anything to like reflect on to influence that decision.
Correct.
Which I think would be wild. But I also, this is just my 2 cents opinion, full opinion here, personal opinion. Why would he do it? If he got reelected anyways, what would be the point in pardoning himself? Just saying, I think that would be a waste of time and energy to duke that out in the Supreme Court when he'll probably be duking out a lot of other things. Would not be my priority.
Well, and you make a good point, and that's one of the other issues is one of the questions of having been convicted of the 34 felonies, because he was convicted of felonies because it was the jury decided that it was in furtherance. These business frauds, these false business records were in furtherance of another crime. Now, they didn't have to say which crime. That wasn't the jury's decision. They didn't have to say it. They just had to believe that it was in furtherance of some crime. Now,
and the prosecution presented that it was an election crime. That was essentially it. You know, the whole like guilty act, guilty mind, you generally have to have both. And so the guilty act was falsifying the records and the guilty mind was doing it to tamper with an election. Essentially, that's super oversimplified. But basically.
No, but that's the idea of it was, you know, did he pay Michael Cohen back for what he advanced for Stormy Daniels' silence? Did Trump pay him back at like a 3-to-1 ratio? I mean, the crazy interest he put on it.
And I said, Michael Cohen and Stormy Daniels could have got more. Personally, I would have asked for more from both of them.
Right, millions, seriously.
That's what I'm saying.
But yeah, so it was the idea of, okay, look, the business records are false because he wasn't paying Michael Cohen for legal services. Right. What the prosecution was saying and what the jury agreed with was these were false because they weren't paid for a retainer fee. They weren't paid for legal services. They were paid as reimbursement and interest on the reimbursement for payment to Stormy Daniels that Michael Cohen fronted.
Now, I would have thought it would be interesting if they were able to convince the jury that paying off somebody is legal services. But then I thought about it, and the professional rules of ethics, I'm pretty sure, prohibit that. But I think that would have been a fun argument, that your legal services can include being a messenger for hush money. I think that would be so fun, just personally.
No, and that's a really good point, because ethically for lawyers, you know, as many people think lawyers break a lot of rules of ethics or don't have any, which, you know, there's good arguments for, especially with the Supreme Court.
You only hear about the bad ones, guys. You only hear about the bad ones.
Exactly. And technically the ethics rules in almost every state have at least some version of what you can and can't advance as an attorney on behalf of your client. Most of those advancements are for things such as court costs, for paying to file a lawsuit, for paying to serve process on another party, that sort of thing. Pay for medical records when you're getting those. That can be paid back after conclusion of the case. But it's not advancing hush money. It's not paying off somebody. You can't call that a legal service or proper advancement of money by your attorney. Same for book deals. There are different, ethical rules for getting money off your client.
Do the same thing.
Exactly. So in this case, the prosecution was saying, okay, look, this is clearly false. That was their argument. This is not for legal services. This is reimbursement and repayment. So he lied on the documents.
Yes.
And then what they were saying was the criminal enterprise that they were trying to do was for, like you're saying, the idea that there was campaign finance and election issues or fraud. There's specific limits, right? We don't all know what they are, but we know that there are limits to what you can contribute to a campaign. And the prosecution's argument was, look, this $130,000 that Michael Cohen paid to Stormy Daniels was part of campaign finance. The only reason he paid it was to influence the campaign.
Yes.
So
basically,
right. And because it was hushed up, the idea is that the campaign was swayed in favor of Donald Trump, helping him to get elected in 2016, rather than had it come out, then the idea is that he wouldn't have gotten elected. Who knows? You know, it didn't come out. We don't know. But that was the idea.
Yeah.
So that's what he's been convicted of. The criminal convictions, because it's the felony, they carry up to 4 years in prison.
But as little as just a fine. Like that's I'm sorry. That is a wild, to me at least. I think there's a big difference between paying money and spending 4 years of my life in prison. Like, I don't think there's an amount of money you could get me to trade for that, right? Like, that span to me seems crazy, but it's not. It's pretty typical, but dang.
It is typical. I mean, it usually says, like, our felonies, right? It's something where a state will say $2,500 fine or up to, 5 years in jail. Yeah. Something, it'll be something like that, or a $5,000 fine and or up to 5 years in jail. So there will always be an and or. So yes, technically it could be a fine. Now, the reality is most states will say, look, if you've reached a felony, maybe we do a fine and jail time, but it's not usually just a fine. And in Trump's case, what's the purpose of a fine? Right? I mean, he can pay however much it is, even per felony. Now, in New York State, for this, it has to be concurrent rather than consecutive. Chelsea, what does that even mean?
That was my next question because I didn't know the answer to this. So if you are serving concurrent sentences, you could serve and we're just going to pretend he got sentenced to 4 years for all 34 counts because they have a sentence each, right? They each have a sentence, right? So if they're concurrent, you could serve 4 years for all 34 charges at the same time. You could do 4 years and be done. But that was my question. I didn't know if New York had any laws about it must be consecutive, which means you would serve 4 years and then 4 years and then 4 years.
Times
on
34.
and on and on.
Right.
Yeah. Whatever that math is.
No.
Someone who's not me can answer that.
That's right. So concurrent means at the same time.
Yes.
Consecutive means back to back. So for concurrent, you can have 4 times 34, but only ever serve 4 years. There are people you will hear often in the media, they have, 2 consecutive life sentences. Well, what does that mean? Well, you serve a life sentence and then you serve another life sentence. Now, in theory, it's concurrent, right? Because you only have one life. But legally speaking, it is consecutive because they don't mean for it to be served all at once together. Yeah. It's most significant if it's a case where you have a murder and then a gun used in commission of a felony, where if you had 5 years on a gun charge and 40 years on the murder charge, then that's 45. If it's consecutive, where if it's concurrent, the 5 years is wrapped up in the 40 years and you still only serve 40 years. So that's how it goes. But in this case, in New York, according to their rules, as I understand them, and we are not New York attorneys.
Oh my God, no.
So as we understand them, it appears that he could at most serve only 4 years in jail, should jail time be an option.
Yeah.
There is always probation. Now, probation, and I did check out, I'm pulling up all of my notes on everything here. Excuse me.
This is the fun part, because probation essentially can be whatever the judge decides the rules are.
Yes.
Like there's not every person who gets probation has to abide by these things.
Correct.
The terms of your probation are really up to the judge. I'm just like chit-chatting here while you go through your notes.
No,
I'm
but
just
that's
chit-chatting.
true.
But
It's chit-chatting in the sense that you're still providing the legal analysis, which is exactly correct. Is probation, there's no teeth to probation if you're just put on probation and have no jail time holding over you.
Don't do this again. And then that's your probation. Or it could be don't travel out of the state. Don't live within, I'm thinking about for other crimes. If you've committed crimes against children, you can't live with this in this, I have no idea how to speak today, apparently, this close to like a school or all of those things.
Correct.
But it's very customizable, which I would not want. Okay. There are a lot of jobs I would want to have. I would not want to be the judge in this case. And absolutely not. And sentence him, just absolutely not. I'd be terrified.
No, exactly. And we're going to make sure we circle back to that in just a minute, because that's really important to be talking about. But you're absolutely right. The probation is not one size fits all. It's per defendant. So in this case, in a way, Trump's actually in a better position than most other defendants. Most other defendants would be like, okay, well, there is the normal probation. There's, don't get involved in more criminal activity, right, in the next year. There's usually a term of good behavior is what we call it. Be of good behavior for a period of 1 year, 2 years, up to 4 years.
Don't hang out with other felons.
Right.
Can't do that.
Don't get a gun when you're not supposed to have one. There are all of these things.
We'll get to that.
Right. We're going to come to that too. So stay tuned, right? We're trying to hook you. So there are things like, okay, be of good behavior. And then they can say check in with a probation officer, right? So if it's full probation, he will be assigned a probation officer just like every other convicted felon. Right, in New York. This is not a surprise. This is not something specialized for Trump. Yeah. If it's specialized for Trump, it will be like, well, he's the president. Can we not find him? We always know where he is. Right. Do we really need him checking in with a probation officer? Why would we give him drug tests? Because most types of probation also include drug testing. Most probation includes checking in with an officer, updating your address, letting them know if you're going out of town, out of state. Yeah. These are normal provisions for probation. But in looking at Trump, it's like, really? Why would we prevent him from going out of state? Maybe he should let us know, but why would we we follow him on the news every day. We all know where he is.
I mean, you can just check his Truth Social. I'm sure he'll tell you what he's up to.
Right. So in this case, it's good for him that it's not one size fits all, because does it make sense for him to be taking drug tests? No, really not. This isn't a drug crime. It's not a crime of violence. It's a crime that he was convicted of, but it doesn't quite merit the same degree. So
restrictions.
In New York, there's 3 different options. Is it a deferment? That was what I was trying to look up. It's a conditional discharge, and that's a suspended jail time, which is usually the good behavior, right? Don't break the law in the next so many years. If you break the law again, we're going to come and make you serve whatever jail time we put over your head. Probation is the same thing, except it gives specific conditions other than just be of good behavior. But both cases involve jail time. So it would be, let's say the judge says, look, I can only give you 4 years, but I'm going to give you all 4 years because it's 34 crimes. So I'm going to give you all 4 years, but I'm going to suspend it all. So you will never serve a day in jail. It will only be suspended on you on the condition that you follow the following provisions.
Oh, sorry, I was going to say this. I didn't know this existed before law school, this type of arrangement, but it's actually way more common than you would think. I mean, we've had clients who had similar, it's called something different in Maryland, but essentially a suspended sentence. I had no idea that this was an option in most places, which I think is fascinating. And especially, everyone knows, if you've watched the podcast, you know how I feel about Donald Trump as a person and what my personal opinions are. However, he is a first-time offender. He is a first-time offender.
He has no prior convictions.
Like it or love it. Like it or love it. This man is almost 80 years old and has never been convicted of a crime. Correct. And that is one of the things you look at when you're sentencing someone. I mean, that is our first argument when we have had any clients that have been in a criminal case and they are first-time offenders. And that is the first thing we tell the prosecutor.
Exactly.
We will agree to these terms. They won't do the following things if you will suspend their sentence for this long of time because they are a first-time offender.
Right.
And it's worked most of the time.
Yeah, and a lot of people think, well, if you're sentenced to 4 years of jail, you serve 4 years in jail. No. Not usually. And so with exactly what you're saying, there's the idea of the first offender and even lesser offenders, where there's a sentencing guideline, sentencing reports are put together by every state or federal jurisdiction. If someone is convicted, and a lot of people have been asking, so let's talk about this, is why is the sentencing set for July? It's set for July 11th. Why didn't the jury just set it? Why didn't the judge set it the next day? Shouldn't he have known? Well, the purpose is to put together this sentencing guideline.
We love our pretrial services departments.
Yes, and that's what this is. The pretrial, the probation and parole offices, whatever they are, whichever one in each state, they go through the defendants, the convicted felons' prior convictions. And if there are none, you get a big fat 0 on that part of the guidelines.
Yeah.
Has he, done drugs that you know of? 0. Has, all of these other things. And in the end, in most states and federal jurisdictions, despite the number of felonies he's been convicted of, the reality is, as a first-time offender, it's probably going to be saying 0 to 6 months.
Yeah.
Of jail is recommended for this case.
I was going to say, we did this together because I was in law school in DC, and I had, because it's DC, had federal sentencing guidelines, because they're not mandatory, they're guidelines, and what that would be. And then you were like, oh my gosh, let me show you the Virginia ones. And you compare them. And I think you're right that if you put it into that little matrix, it's like, and anybody, to be fair, anybody can pull this up online. You can look up your state's sentencing guidelines, and you can go through all of the things that will move you over on this graph and tell you what the recommended sentence is. I don't know New York's, but I would bet it is less than a year.
It's going to be similar. I mean, that's the idea. And the other thing that people don't know is, I can speak to Virginia and Maryland, especially Virginia, where I had most of my jury trials, is when you have 34 altogether, you don't go much higher on the guidelines, where it's okay, it's, it says something like 2+ felonies at the same time, and you get an extra 1.
It's a point bump.
Right.
But that might not even move you on the graph, right? You get all of these points.
You don't
now, the one I think he would get counted
34.
off on is one of the things, at least on the federal ones, that's the ones I'm most familiar with, is admitting guilt. He would not get that point on that. And I do think that's probably pretty common.
Yeah. So he's not going to move high. Most likely it will be some kind of range of 0 to 3 or 0 to 6 months. That doesn't mean that the judge can only sentence him to 6 months or 3 months or whatever it is. He can be sentenced to the entire 4 years, but the service time is what we're looking at, the 0 to 3 or 0 to 6. So the judge would be like, look, your guidelines are 0 to 3, 0 to 6, whatever it becomes. So I'm going to sentence you to 4 years with all of it suspended, conditioned on these things. Yes. That is an extremely normal option. In Virginia, here's another interesting piece. In Virginia, the jury is never told that probation's an option. Ever. So there's jury sentencing. So the jury is never told.
Well, the sentences, right. But what?
So what happens in Virginia is it's usually a bifurcated process where you have the guilt decided first, and then if the defendant, he or she, is found guilty, then they go into the sentencing phase, and it's immediate. So you have to pick it up immediately and be ready to argue sentencing. And the jury comes back and provides a sentence, but they're only told, look, this crime, let's say it's a Class 6 felony, that's 0 to 5 years, okay, which would be similar to the New York rule here.
Yeah.
They could be told, look, you can sentence this defendant, this convicted felon, you've just convicted him.
Yeah.
Now you can sentence him up to 5 years for each of these crimes, okay? 0 to 5 years, that's the range. We ask that you find 5 years for each. Now, let's say that's the rule. Well, the jury, that's the only option they're told. What they don't know is if they do the full 5 years times 34, there is still the final sentencing later, just like this New York case, where then a sentencing report is run, the guidelines are run, and in the end, the judge can say, okay, well, it's, 5 years times 34. Well, that technically isn't allowed, so we're going to have it 5 years, and I'm allowed as the judge to suspend it. The jury can't give suspended time, but the judge can. So the judge can convert the sentence of the jury in Virginia to include probation time. So we have all of these complications.
I have such mixed feelings on it because, one, I already think, and I've said this 18 million times on this podcast, that juries are given the toughest job because I went to law school and passed the bar, and I'm still confused half of the time reading about these things. And we just are sending civilians in there like, go get them, Tiger. Like, good luck. I can't.
Go interpret the law.
Go interpret the law. Congratulations. And then sentencing is the same way. That's extremely complicated.
Yes.
So part of me is like, well, let the jury sentence stand and give them all the options. And part of me is like, these poor people, don't give them any more things to read.
It's so hard.
Any more things to read.
Yeah, it's so hard. And I want to talk about that as to what the jury could consider and what they couldn't. Yes. So one of the interesting things is, and I did not realize this until later, but we found out that the jury instructions, these are instructions that are given to the jury before sentencing or before
explaining the law.
Right. In considering this case as to the defendant's guilt, this is the law that you have to keep in mind. There's basic rules like, you're the ones who determine whether a witness is credible.
Yeah.
You can view the behavior of the witness, what the witness says. It's up to you. You cannot consider
if the defendant doesn't testify.
Exactly.
So like your parameters. It's like, here is the box in which you can consider all of the arguments that you have heard. Good luck.
Yes. So that's what the judge instructs. And that's based on the law. And it's based on what the prosecution and defense put forward as requested instructions. So if one of the parties objects to an instruction, there's a hearing, and both parties can argue whether it should or should not be given to the jury. And in this case, it's really interesting because there were two issues that people have come up with regarding the jury instructions. And one that's being suggested is that, and I think this was put out by Trump, and again, I don't know, we've said this before on the podcast as well. I don't know how much is a true misunderstanding of the law versus how much
intentional distraction
he's trying to rile people up with misinformation about the law. And I don't know. But Trump has said, look, the judge told the jury, what is this? That they do not need unanimity to convict. Okay. So that's what has been put out, is this idea that the judge instructed the jury, you don't have to have a unanimous jury verdict to convict him. And they're saying, this was unconstitutional. Well, that would be if that's what they were told. And that's absolutely something that would be a grounds for overturning the case on appeal. Because if a criminal defendant does not get a unanimous verdict one way or the other, then
it's a hung jury.
It's a hung jury. And you cannot have a conviction or a finding of not guilty. And if they had if that had been an instruction, then there would have been something to overturn the case on. But that
you would get me out there agreeing with them. I would be on there being like, this was wrong.
Absolutely. But the jurors were instructed instead, the actual instructions said that they, quote, must conclude unanimously that a defendant conspired to promote or prevent the election of any person to a public office by unlawful means, ... and that they, quote, need not be unanimous as to what those unlawful means were.
Which makes sense.
So, yes, he heard it doesn't have to be unanimous, but that was as to what the underlying crime was.
Right, but if you just say, the layman's terms of that are what you said at the top of the episode. Did he do this to promote a crime?
Yes.
There you go. It doesn't matter what the crime is. It doesn't matter if the crime is election fraud or the crime is fraud or
tax
the crime
fraud,
is murder or whatever.
Robbery.
Right. So you could go around the jury room and be like, is assuming everyone has already unanimously said, we think he did this.
Yes.
Do you think he did it because of crime? Yes. You don't need to know what crime it is.
Right. And there's not a box for them to fill in. Okay. The jury doesn't have a box that says we think it was this.
Right.
It does not matter. The unanimity is, did he do it?
Yeah.
They don't even have to say to each other what they think the underlying crime was, what the advanced crime was, what it was supposed to be going toward. They just have to agree that it was going toward any crime.
Right.
So in
criminal endeavor. I mean,
yes.
The jury instructions also, I'm sorry, they're so long.
Oh,
this is my least favorite part, to be clear, about any of the trial ad classes I did. I hated arguments on jury instructions. I hated them because they are so complicated.
Yes. Yeah. So exactly. It's so complicated. It's so dry. And I think what's telling in this case is the jury came back several times with questions asking the judge to reread portions of the jury instructions. I don't know which ones they were. I know it was reported, but I didn't go back. The number of them, it wasn't worth it to me to go through which ones were called back. It wouldn't surprise me that this was one of them because they could choose in this case to 3 options. Again, they didn't have to write down which one it was. They just had 3 options to consider. The violation of the Federal Election Campaign Act, falsification of other business records, or violation of tax law. So any of these are unlawful means. They aren't charges themselves, and they won't result in separate convictions. So they don't have to be agreed upon. And I think it's just important to know what the law is and what it isn't. We're not saying we agree with the conviction. We're not saying we agree with the juries. We're not saying any of that. Now, we have our personal opinions, which you can probably guess.
I will.
But in this case, what is the law? And in this case, this was the agreed jury instruction. Now, here's where I think the defense messed up. Okay. And
do you want that list alphabetically or chronologically?
Right. And honest to God, except for, and Dr. Weil was key on this before, where he's like, look, I'd say it was bad defense lawyering, except for the fact that Trump could choose any defense attorney he wanted and pay a lot for them. And he probably ran a lot of the defense himself. It was probably a lot of his own decisions. Now, he is the type of person who has usually then contradicted later on what he agreed to or not. So it would not surprise me, true or not, whether he later says, no, they went against what I asked them to do. If it will suit his case, if it will suit his needs.
Right. And if it suits him and he's not, separately bringing action against the attorney has kind of backed themselves into a wall, right? Where you can't be like, actually, nuh-uh, that's not what happened.
Right. And it's one of those things of the defense failed. Like you said, there are so many things, and we have reviewed that, okay?
Yes.
There's a podcast recently that we did. I think the title was something like Trump Defense, Was It Harmful or Boring? Right?
Yeah.
Where we analyze a lot of what the defense did. And it's the one time I felt sorry for Trump. And a lot of people can hate me or disagree about it, but I did actually feel sorry for him because I felt like his attorneys did him a disservice. Whether it was on his insistence or their own trial strategy, I think they made some mistakes that harmed his defense.
I absolutely think the attorneys made critical errors and also possibly malpractice. I just lacked the sympathy for him on that. But I absolutely agree with you that that was...
Here's another way. And when talking about these jury instructions and conviction, the last way I think they messed up was they did not ask for an instruction that allowed the jury to find him guilty of misdemeanors.
This has been my contention. If you look at any of the episodes, like weeks and weeks and weeks, months back, that is what I've been saying the whole time. As someone who personally, and you can see my personal opinions, I don't like him. I don't like him at all.
Sure.
But I have said repeatedly on this podcast, I would have a hard time convicting of the felony.
Yes.
I could easily convict him if I was on this jury of a misdemeanor, but not of the felony. when I saw that was not part of the jury instruction, how is that not? How is that not malpractice?
Ask for it, and it's a trial strategy.
That's what I'm saying. It's a trial strategy, but to what end? To what end was that a strategy?
I think I know why. I think it was a poor
please fill me in,
strategy.
because I'm just a baby attorney running my mouth.
No, you are not. It is. I think it was a poor strategy, but I think they had a strategy.
Okay.
So for everyone who doesn't know, the misdemeanors would have been just that they were false business documents. Okay.
Easy.
It rose to the level of a felony if they were done in pursuit of another crime, right? Which is what we're talking about. They had to be unanimous that he committed a crime, but not unanimous as to whether it was going to something else. Why? But if they found that it was done for an illegal purpose, then it's a felony. But if it was just done, yes, it's still an illegal act to falsify business records. But if it was just the falsification of business records, then it could be misdemeanors. And we talked about this. You're right. We had different things. I think Dr. Weil was saying he thought they'd convict on the 7 ones where Trump had signed the checks, but not the others. You and I had talked about, well, not necessarily the felonies, but maybe some misdemeanors. Yeah. I really thought about, a hung jury. Yeah. But in this case, the defense only submitted the question for the jury, for a jury's instruction of, you must find him guilty of that he falsified business records and that it was in furtherance of another crime. If you do not find these things, you must find him not guilty. Okay, so it was guilty or not guilty. Those are
not the real options here. Lesser included, baby.
Yes, a lesser included offense is, okay, you have to prove all of these things. And if you prove all of these things, it's at least the misdemeanor. Then if you add one extra item, then it's the felony.
Yes.
But if you don't find that one extra item, there's still all the others that you've proven. So it's the underlying offense, right? It's the lesser included offense. And they did not give on something. Yes, they didn't give the jury that. Mm-hmm.
Okay, this is how I tried to explain this, because my mom and I obviously have all of these discussions off air, and my mom is not in the legal field at all. But she had to hear, because of COVID, the first year of my law school experience, she got to hear live. And then she heard me studying for the bar. And I was explaining to her, you're going to laugh when you hear this, the common law definition of burglary, right? To commit a felony with it was critical to that. And I was like, so if you broke in just to sleep there for the night, that's not a felony, right? And this is how I explained to her. I was like, this is basically like the parallel of that with a lot more complications. But it was like, what was the intent when you broke in? Right. If you broke in to steal, that's burglary. If you broke in to sleep, not burglary.
Right. Yeah, it's exactly that, is what is the intent? And if you find the extra intent, then it's a felony. I think it would have given the jurors a better option to not find him to be a convicted felon.
Yeah.
That they could have said, look, okay, we do think he falsified these business records and that he knew about it.
Yeah.
But I
don't know why he did it.
Right. We don't know why. We don't think it was necessarily for another crime. Maybe it was to prevent his wife from finding out. Right. But the defense went all or nothing. It's either felonies or it's nothing. And I think they did it with the hope that the jury would have to find him not guilty. That they wouldn't have another option.
This whole thing is a witch hunt. All of it is bogus. Of course, I'm not
guilty. You can't find me guilty of anything. So I think that was the strategy. It is a hard question of, in some of my jury trials in Virginia as a prosecutor, it's like, okay, well, it really sucks that if I've charged first-degree murder, that they have to be given an instruction on second degree. And then voluntary manslaughter, and then involuntary manslaughter. But that's the lesser included.
You could charge first-degree premeditated homicide, and they come back with involuntary manslaughter most of the time.
Absolutely. And that was one of my hardest trials.
Yeah.
Was a malicious wounding in Virginia. And malicious is the higher.
I think about this no less than once a week because it is insane.
It haunts me. It really haunts me. Someone beat an older woman almost to death, crushed and split open her head. It was a horrific crime. And we charged him with malicious wounding because that's basically, It's like attempted homicide, but it has higher degrees. It's like a permanent injury, a severe, serious permanent injury with intent to do so, with intent to cause it.
Right, you wanted to maim them. You beat them to maim them.
Wanted to. And it was like at the time up to 40 years, right? And then there's, okay, well, if it's not that, then it's at least unlawful wounding, which is you didn't necessarily have the intent to permanently maim or kill them.
You wanted to beat them up, but you didn't want to seriously hurt them.
Right, but it wasn't that bad. Or there's the full underlying, which is a misdemeanor assault and battery. And I was the same way. I was like, well, it's malicious wounding. How can they find otherwise? And in the end,
accidentally cave somebody's head in, right?
Like, it's like, how is this possible? And in the end,
maybe you do. I don't know, but I do.
The jury found him guilty of only assault and battery, which was a year in jail, max. And I was devastated. But that was the law. That was the underlying. And the defense won. It still haunts me. But do I say, and let's get to this, do I say at the end of the day that the jury system is corrupt?
No.
That we should burn it down? No. On the whole, I still support the jury system. It is the best system that I know of. It has flaws. It doesn't always get it right. I have my opinion as to what I think is right. But in the end, the jury didn't think my conclusion was correct.
Right. And I think
that the defense was.
I think you said that perfectly. We talked a little bit about this off air before, is that as someone who tends to be in my person, I tend to be a burn it down person. It's broken, burn it down, start over. Yeah. That is how I skew. I think that's abundantly clear to anyone who's listened to any of these episodes. But I actually think when it comes to juries, I don't know if that's where I take my problem with. Now I have a lot of things to complain about in the criminal legal system, but the jury system isn't one of them. So if you had, and I say this, especially in the cases that we're talking about today of two extremely wealthy, powerful white men going in front of a jury of 12 where they can afford the best legal counsel, they can afford teams of legal people. And if 12 people decide that you're guilty, you're not going to hear much from me about it.
Right. And that's right. There's never going to be, we're all going to have different opinions as to whether the jury got it right. But on the whole, I'm going to trust the opinion of the jury. I don't always like it, but I'd rather have the jury system that we do. And it is made up of different voters. It's made up of different peer groups, right? A jury of your peers. And in New York, the jury of your peers is the New York citizens. You don't go find peers in Florida for a New York case, right? Now, he's got a Florida case. And even though it's federal, he may find jurors that are more favorable to him simply for the jurisdiction that it's in. But he wouldn't want to give up that positive for him.
Right.
To not have
the system isn't rigged against him. I'm sorry. It's just not. Now, there are a lot of things where I think people do not get fair trials every single day in this country. This one, you have an uphill climb to convince me that this one was somehow unfair.
Yeah. And this is the hard part. Now, you talked earlier. Well, okay. Real quick, let's finish up the possible implications. He can still run for president. He can still be president.
Can I tell you the funniest thing I saw that is about this? This is on TikTok. This did not come from me. And someone said he can be president by Air Bud law. Well, I guess there's no rules saying he couldn't, which is like the plot of the Air Bud movies, the like dog and sports. And so someone said he could be president by Air Bud law. That is the funniest thing I have heard in weeks.
It's pretty funny. And it's not, inaccurate.
It's not true.
Right. So he can be president, even though a convicted felon. He can be president even with pending charges and investigations. He can be president from jail. Okay. Now, is it good for the country? No, probably not.
It's allowed.
It is allowed.
I struggle with this because I do think people who've been convicted of felony. My general belief is that people who've been convicted of felonies should have their voting rights restored, should have their ability to do these things. And I'm not going to change that for him. That has been my belief for a long time.
Benefit. So and I think he should be able to do it. Why does the voting right issue matter?
Well, there's a whole question of okay, he's now a convicted felon. Can he vote for himself?
Can he vote at all?
Can he vote at all? Right. And we're assuming it's for himself. Now that would be a plot twist.
Right.
He votes and votes for Biden. I mean, dang. But can he vote? And in a lot of places, of course, I don't know all state laws across the country. A lot of places, convicted felons cannot vote.
Correct.
Generally. Now, there's been a lot, especially in the past 5 to 10 years, of reform across the country. A lot of people are, sort of lobbying to have that changed. And Florida actually is one of those places.
Yeah. Well, it's weird. It's New York. But Florida has
where his conviction is, excuse me. He would be voting ostensibly in Florida where his residence is, right?
Correct. So he has changed his residence from New York to Florida back in 2019. And Florida rules say that whatever jurisdiction you were convicted in, if they have restored your voting rights, then you can vote, whether we think you should or not.
Right.
And in New York, there was this voting act passed that allows convicted felons who are not in jail to vote. And because of that, Florida says we're going to honor that
as long as they finished their
state.
sentence and paid their fines, I believe, are the two things.
Yeah, one or the other, certainly. But basically, you can vote as a convicted felon with certain conditions, and he appears to have met most of those conditions, if not all. And Florida says, okay, if the state you were convicted in has approved you to vote, then we're going to let you vote here. Yeah. So he would be advantaged through that particular rule. There are many that he, would be disadvantaged by, but that's one advantage. Now, he possibly can't carry a gun. Many convicted felons.
Do we think he is already? I mean, Secret Service, I think, kind of.
Yeah, his little troop with him, a Secret Service. You'd hope that you wouldn't have to carry a gun. Everybody else is carrying a gun on your behalf for you. So it may not ultimately matter, but technically, convicted felons can't have guns, at least through most federal law and most state jurisdictions. But again, sometimes it depends on what felony it was, whether it's a crime of violence. We're going to get to that on Hunter Biden. Yes. But he may not be allowed to carry a gun. And at least I don't think you can get the Utah license. And the Utah license is one that, you have so many states, if you do certain classes and meet certain requirements, that you have reciprocity and can carry a gun through many jurisdictions, not just your own home state. Yeah. So he couldn't get the Utah license. But there are other states he could, possibly New York, possibly Florida. I don't know. One of the most interesting effects that this has, though, is if he is president and this conviction remains, even on appeal, it's still there unless and until overturned on appeal. He is not allowed, I think it's in 33 to 35 countries. He's not allowed to go to them as a convicted felon, including England.
Yeah.
And I think it's Australia, England and Australia, some of our closest allies. I think it's England, Australia, France, some others. But
thank God for Zoom.
Right? I mean, do you have a presidential, discussion with another leader by Zoom? Can you encrypt it enough? Make it secure? I don't know. So I think that would be the hardest piece of it to overcome as a practicality.
Mm-hmm. That is where you lose me. Now, do I have a slight morbid curiosity? A little bit to see how this would theoretically play out?
Yeah.
Kind of a little bit. I mean, not because the risk here is a lot to me in my calculations, but do I have a 10% morbid curiosity to just see what would happen?
Yeah. And I mean, that's what we're seeing right now anyway, is what about presidential immunity? Are you immune for any act that you do as a president, whether it's in furtherance of your presidency or in furtherance of your own personal campaign for a presidency? That's what's being considered now. Nobody thought we'd ever have that issue. Nobody thought we would have, can a president pardon himself? And it's a real question right now. Now, we had Nixon and is it Ford who came after him? I
wish your dad was here because this is not the question for me.
But the president after Nixon went ahead and gave him immunity and said, okay, look, I'm pardoning you for any and all federal offenses. So he could do that. He did do that. And ultimately, Nixon wasn't even put on trial. because he was pardoned for any offense he did. He wasn't pardoned after he went through trial and was convicted.
Right.
He was pardoned for the crimes, any crimes he possibly committed that were federal. No state pursued state action against him. So there wasn't an issue of that. It was just federal issues related to the Watergate scandal, related to the cover-up more so for him. So we're reaching new uncharted territory. But I want to return for a final piece of this Trump issue to being scared of being the judge or the jury.
I don't say that, and I'm not scared of much. So I mean that sincerely. I would be terrified if specifically the judge, because I mean, that's easier information to find, but it's not impossible to find the rest of the information for the jurors, which is what you're going to talk about. I would be scared, especially if I had a family.
I do not envy these jurors. They have been put in an impossible situation. They did the duty that our Constitution requires of them. And thank goodness, because we need them. We need jurors.
Critical part of how the system works.
Right. And just because they're on the Trump jury, there are at least attempts to have them doxxed. Now, what does that mean? Chelsea, on to you.
Internet generation,
You're the right
baby.
generation.
I mean, doxing, in the simplest terms, is publishing addresses, phone numbers, workplaces, all of these things to forums generally where they can be used for bad purposes. And I mean that very broadly is what doxing is. I mean, was it a year, 2 years? Time is an illusion. But a couple of years ago, the Supreme Court justices' addresses were leaked.
Got published.
And that's what doxing is, right? And it's become this thing. As someone, and I will own up to it, I'm an internet sleuth. I can find anything out about anyone. I'm really good at it because I'm nosy. And that's why I went to law school, to be in people's business. But people are finding, because these are normal people, right? Normal people don't encrypt all of their stuff. They don't take, they post pictures of them and their family and their kids and their first day of school to Facebook.
Exactly.
And if you have enough time and energy, you can find this information out.
Exactly.
And then to publish it to forums where, are you going to read some of these messages that are
go ahead. Please continue though.
No, where these people who, ostensibly are just normal people who did what they are called to do and served in a jury are now being doxxed in really terrifying and scary ways. And so their personal information where people can show up at their houses, people can show up at their workplace. And this is being published specifically to forums where people are calling for grotesque, disgusting violence.
Yeah. I mean, I'd be wanting to be on the witness protection plan as one of these jurors.
And is this what we want for juries? Like this, to me, we already have a problem.
You're discouraging democracy and people wanting to participate in democracy. Whatever you think of the system, it's better to have it, right, than not to have it. And
I don't want anarchy and lynch mobs. I'm not interested in. And I have someone who has a lot of criticisms about our system. I don't want anarchy and lynch mobs and vigilante justice because what does that look like? I don't know. Maybe Jim Crow in the South. Maybe that's what that looks like.
Right. And as bad as our system is, for two attorneys here, and Dr. Weil, I know, would agree as a constitutional scholar and political scientist who really focuses on the founding of America and the creation of our founding documents. We are not sunshine and lollipops here as a country, but is any really, right? We started the country with slavery. We started the country with a 3/5 of a man rule in the Constitution. But on the whole, we still think it's, an emerging continuous document. We've gotten rid of slavery. Now, is everything wonderful? No, we've got a long way to go, but we at least got to that. Then we had the Jim Crow era. We had, we still had African Americans not able to vote. Then we had segregation. We've had people not allowed to have attorneys. We've had, most
not
of us
have a jury of their peers.
We know Miranda now. Miranda versus Arizona, this is only recent. This is within the last century, less than that. The ability for defendants to have an attorney and to have one given to them if they cannot afford one themselves, these are new innovations.
I mean, we've talked about it. Batson violations were like in the 80s. Like my parents were alive within the time of like, you have to have a jury where they're not just striking everyone who's not white, right? Like that has happened within my parents' lifetime. This is not, like you said, this is a new concept.
Yeah. And I don't think anyone would want to go back to the past, but it doesn't mean we burn the system down. We've used it to progress, to add rights to people, to we have a long way to go. We will always be striving toward perfection, but we will never get there. But it's not something to give up on. As someone who truly believes in the legal system, even with its flaws, that's the reason the country has gone so far away from capital punishment. Right? We're getting rid of that system. How many states don't even use it as an option? We go from what type of capital punishment we've had to, we're looking at hangings and shootings and all of these others to now it's lethal injection for the most part. And again, it's progressing. It's using what we had as a basis to continue to improve. We wouldn't want to go back to the prior system, so let's continue to improve on it rather than get rid of it. But truly, these jurors, it's...
And demonizing people who are participating in this system is helping nobody, making people afraid to serve on juries.
It's almost like the draft. You would have to, at this point, draft me to be a juror.
See, apparently I was born without fear because I'm like, put me on the Fulton County jury. I'm going to email them and be like, can I please be on your jury? And they're not going to let me, obviously, but I would volunteer.
Right. But how many people would now?
And I wouldn't blame them.
I wouldn't want to be told that I'm, a Biden administrator, lackey who's
Are you not? Are they not paying us right now, Virginia? I thought we were getting paid.
I get no money.
Yo, just in case someone heard that, I am joking and the look on my face says that.
Yeah, we are not paid by either party, by any representative. We're not even paid for this show at all. So, it's one of those things to be able to have the jurors' addresses or alleged addresses put out there. And for people to be saying on fringe websites, quote, we need to identify each juror, then make them miserable, maybe even suicidal. Another person wrote, 1 million men armed need to go to Washington and hang everyone. That's the only solution. So are we going to go back to vigilante justice? The only we've had in your neck of the woods, what have we had recently, right?
I mean, within the past couple of years, so I'm in Georgia. I'm a couple hours away, but like in the Savannah area, we had Ahmaud Arbery, who essentially, this was vigilante justice, right? Like we have two men who believed they were right. And it was two white men in Savannah, believed they were correct, believed they were, in their minds, to be clear, they believed they were doing the right thing. And I think that you can't really dispute it. They were true believers, right? And they killed somebody. They killed a man who was doing nothing more than running in their neighborhood. And his, to be clear, I say there, but in a neighborhood. That's crazy because, of course, we all think we're right. We had this conversation off air. There are times when I look at people who do vigilante things and I'm like, as they should. But the reality is, I can't endorse that because I always think I'm right and you always think you're right. And we don't agree on those things. And I would much prefer our broken system touch it than we allow every single person on their own with their own beliefs and biases to be judge, jury, and executioner.
Yeah.
It's better than that. It might not be better than everything, but it is better than that.
It's not. But use the system as an attorney, as someone who believes very much in democracy and the American system. Yes, let's fight for better justice, greater justice, less bias, less, corruptness. Many government officials are corrupt. I don't know who, but
and if you can figure them out, prosecute them.
Yes.
People think that this is bias. No, if you can find anyone in any political party who has committed a crime, good, prosecute them. Prosecute them. And you're not going to hear a complaint from me.
Yes.
It's not just about this one person, former president, being prosecuted. If you think there are people doing corrupt things, go to your prosecutors and convict them then, or charge them, prosecute them. And you'll hear support from me personally.
Yeah. So let's talk, let's wrap up the show with another prosecution. Speaking of someone who is also under prosecution right now, being prosecuted, has not been found guilty yet, or convicted or not convicted. We've got Hunter Biden on trial. Now, Chelsea, give us a quick run as to who he is and what he's being charged with and why it matters.
Okay. Unfortunately, I was sucked into the rabbit hole this morning. And I will be completely honest. I vaguely knew who Hunter Biden was and didn't know a lot of the information about him. And boy, in the past, I started looking at 8 a.m. Past like 3-4 hours, I have learned a lot. Okay. So he is President Joe Biden's second son. His first son, who was the older boy, unfortunately passed away not too long ago. So now we have Hunter Biden, who ostensibly has struggled with drug addiction and substance abuse disorders his entire life.
Long time.
In my terms, hot mess. I mean, in the most respectful way, hot mess his entire life. There's some interesting personal history that I found personally disturbing about the women he's been in relationships with, to include his dead brother's wife.
Yeah.
Not my business, but yikes. Yikes.
He doesn't seem like a wonderful human being. Right.
And then there's no part of it. I'm like, wow, this is a good person. It's what I said about Trump and his cronies. If you're surrounded by yuckies, you're also a yucky, right? Like, these are yucky people.
It seems to, who you surround yourself, is a reflection of you.
But we're going to migrate over to Delaware for a second, because this is where this is all playing out.
Is it state or federal?
Yes, it is federal. So this is not the same as like the Trump New York thing where it's a state law. This is a federal offense, but it's in the whatever. I don't know what circuit that is, to be perfectly honest. It's in Delaware. And he has 3 charges that are coming against him. And essentially, he lied on a piece of paper to get a gun. That is the breakdown of it. And this is the part that I was fascinated by. Legally, he had a plea deal. The defense and the prosecution had agreed to a plea deal.
Yes.
However, as we know, the judge also has to agree, and that's not what happened here.
The judge refused. And this was a win for Trump, quite honestly.
Oh, absolutely.
Because Trump and many Republicans, they were saying, why does he get a deal to basically, a misdemeanor or something? And
it was a sweetheart deal with no time.
Great deal.
No felony conviction. It was a good deal.
And
if I was the defense attorney...
Yeah, everybody
Absolutely.
was saying, look, we're prosecuting Trump for all these felonies. This is crazy. Why don't we go? It does look bad. If we're not going after Hunter Biden, it looks like we're not doing it because he's Democrat. He's Joe Biden's son. So Why should there be this disproportion? Right? This, let's go after Trump with everything and let's not go after Joe Biden or his son now. I do believe that you have to have evidence before you can even have a prosecution. I do not know what evidence there is or isn't. I also don't know that for Trump. There seems to be more evidence in the news, right? That's been leaked to the news, that's been put in alleged facts and indictments that are more accessible to us versus the Bidens.
So here's the thing. What we've talked about on this podcast is that if you're a criminal defendant, shut up, stop talking, shut up. Stop talking. That is your piece of legal advice. Maybe don't publish a book about your drug addiction. Maybe don't do that, because
And that's what he did, right? Hunter Biden.
And he published a book, and this is not funny. I'm not laughing, but it is kind of funny. I am laughing. Not only did he publish the book, but he authored, like, his own voice is the audio book. So what they are now playing in this trial is his own voice reading the words, detailing his addiction to extremely hard substances.
And one of the charges, so tell us, what does this drug addiction matter? Is he being prosecuted for being a drug addict?
Yes, and I'm going to read off what we have, because I did screenshot it, because I screenshotted. I don't know. I can't speak, obviously. But here's what we've got. So the first 2 charges, the government must prove beyond a reasonable doubt, obviously, that he knowingly made a false statement. For one of the first 2 charges, they must show that the false statement was material to the sale of the gun.
Okay.
And for the possession, so a felon in possession, or that's not exactly the charge. I don't have it listed here in my second screenshot.
Basically, it's a drug addict in
possession
of a firearm.
The government must prove the 3 following elements: that Hunter Biden was an unlawful user of a controlled substance. Well, that doesn't seem to be in debate. at all. He has said it himself in his published memoir, that he knowingly possessed a firearm, and that when he knowingly possessed the firearm, he also knew he was an unlawful user or a drug addict.
Right. So what they're saying is there's a federal form when you get a gun, right? You have to fill out forms.
Unless you're in Georgia and you can buy it at a gun sale.
Right. So usually there are federal forms that you have to fill out asserting certain things. I live at this address. I am of this age, which would be the legal age to purchase a firearm. I've never been convicted of a felony. I am not a user of illegal substances. I have not been involuntarily committed to a mental hospital. I have not been voluntarily committed in the past however many years. There are certain statements that they have to agree or disagree to. And if they answer certain statements in the wrong way, then they can't get a gun. So many people, and this doesn't just include Hunter Biden, and I'm not saying he has or he hasn't, the evidence looks strong against him. But many people will lie on those forms to get a gun. Right? They want the gun. Some people will not admit that they've been committed to a mental hospital.
Right.
People will not necessarily admit that they're convicted felons. And if you don't admit to these things, then you can get a gun. So it's a lot of self-reporting. The government is relying on you to tell on yourself. And what Hunter Biden did was he said he is not, at the time that he purchased it and filled out this form, that he was not an illegal user of substances or was not a drug addict who was trying to purchase a gun.
Right. Which ostensibly, according to him on his voice that they're now playing in court, he was.
Yeah, and the defense is interesting. The defense is positing that, yes, he's been a drug addict. We're not disagreeing. He's definitely been a drug addict. He's had a lot of problems, and he did purchase this gun, and he filled out this form that said this, but at the time that he filled it out, he did not think that he was an addict, and he did not believe that he was taking any illegal substances, because the argument is, like, for the past 11 days, he had been out of rehab. He had gone to rehab and had been released at the time that he had purchased the gun. So they're saying that he believed he was not addicted because he'd just been cured, right?
Yes.
And or that he was not taking any controlled illegal substances because at the time he wasn't, because he had gotten out of rehab. So
is it in that past 30 minutes? Is it that past hour, day, week? What are we saying is the time frame? If you've ever taken a illegal substance,
right,
can you never buy a gun? Are we saying that?
Right. And, we don't want anyone who has had a really hard time with drug addiction to not have guns, right? Just because you've been an addict. I mean, there are some people who will say, once an addict, always an addict. And even if they've been, without a substance
and sober
for years,
decades,
they will still say, I will always be an addict. It is a fight every day not to be. But that doesn't mean they should be penalized for it. Right. So the question is, what is the intent behind the law? What is the intent behind it? Did he intentionally violate the law? Did he know that he was an addict still? Did he know he was taking illegal substances at the time that he filled out the form? Or did the form have a greater meaning? Did it have a greater intention of, okay, so this day you haven't taken any illegal substances, but within how much time period?
The knowingly part is interesting, though, because I do think a reasonable person could read the questions on that form, and having not ingested substances will round up to 14 days. You have not ingested those substances in 14 days, and read that and say, doesn't apply to me.
Right.
A reasonable person could. So knowingly, to me, is where I get caught up on these charges.
Yeah. And this is interesting because I'm going to compare it to the Newport News shooting. We've talked about that case several times on the podcast. This is the 6-year-old who shot his teacher in Newport News. And the way it relates to the Hunter Biden case is the mother of the 6-year-old was convicted federally in Virginia. She had state and federal charges. The state was basically neglect of a child, felony neglect of a child. And the federal was this lying on the gun form because she said she was not a drug addict, but evidence has come out that she was an abuser of marijuana. Now, some people are like, well, It's just marijuana, right? But federally, marijuana is still illegal. And on a request to obtain a firearm, marijuana still counts as an illegal substance. And if you are a chronic user of marijuana, it is still an illegal substance.
We have to define chronic. What makes you an addict? What defines chronic? If I drink every weekend, but I drink on weekdays, am I you know what I mean? I think the hard thing is that the
difference in some of that is what's an illegal versus a legal substance.
Absolutely. I just said drinking because I have a wine glass in front of me and it made me think about it. Like, does this make me? We get on this podcast once a week with a glass of wine or a Jack Daniel's wine cooler beverage. Yeah. And, what is continuous? What is chronic? I don't know if we've adequately fleshed out these terms on these types of forms.
Yeah, and I think it's hard for a layperson to understand these forms. There are case laws, right? There are cases that have fleshed these out more that they're using in the prosecution that says, the law defines this as, but that's not included on the form. Really, you have to, use a lot of self-analysis of does this apply to me or does this not apply to me? So I do think we're doing a disservice to a lot of people who are filling out these forms of having to interpret the law when it's not as clear.
Here we go back to intent, the same issue in the Trump trial. Did he intend to deceive the person? Did he knowingly lie, or did he think he was answering appropriately? What did he think or know at the time?
Did he think it was really for legal expenses?
How do you break that down as a juror?
And I think that's what this jury comes down to, is what does the jury think Hunter's intent was?
Right.
What
I
think he know?
I think that, to be perfectly clear, this is a lot stronger case than the Trump case was. I would be surprised if he didn't get at least one of the convictions.
Yeah, I mean, it seems to be very clear that he's had extreme substance abuse issues, that there's the picture even of him holding the gun while smoking a joint, I think, or something to that effect. Don't quote me on that, but I think there's a picture out there like that, that was brought to light that is like, well, how could he not know? Because he's in this picture holding the gun. But the question is, at the time that he registered for the gun, requested it, he wasn't taking that photo.
And I think the actions taken afterwards, I don't know it personally. And again, I'm in Georgia. I know a lot of people who own guns. None of them have dumped their gun in a trash can, right? Because none of the people I know are doing illegal things with those guns. Right. So I don't know anyone out of lots of people I know that have a gun and haven't dropped it in a trash can. So that, to me, even if you're not supposed to, as a juror, would be like, well, if you were a legal gun owner and thought you were doing the right thing, why would you have your girlfriend, I don't know, whatever you want to call her, girlfriend, dump your gun?
Exactly. And that's why most jurisdictions allow the flight of a defendant to be used in a criminal trial as an indicator of guilt. Is why would you flee if you had nothing to hide, if you hadn't done anything wrong? So it's the similar idea. And different states have, in Virginia, there are crimes for gun with drugs, right? If you are in a car where you're carrying guns and drugs at the same time, then that's a felony charge. There's charges of felon in possession of a firearm. That's a separate charge. So jurisdictions have different charges related to guns. And that's what's tripping Hunter Biden up. Now, let's end with this. Speaking of pardons, Chelsea, you saw the question that someone asked, would Joe Biden, because this is a federal crime, pardon his son?
So he would have the opportunity to, assuming Hunter is convicted. As the president, this is a federal crime. He could do that. I saw an interview, and to be fair, again, I don't like Joe Biden either. I've talked about how much I don't like Trump. I also really don't like Joe Biden, just for all the people who want to be mad in the comments. I hate both of them, to be clear. But the interview was so cut and clear. I can appreciate that. The interviewer asked, if your son was convicted, you're still in office, would you pardon him? There was no, no, it was a simple no. And then he just made eye contact, which was powerful to me because I think you can say this, is there's a lot of belief in the system like him, love him, I do think he believes in the system. And I think if 12 people convict, he would have a hard time pardoning anybody, let alone his son.
And honestly, props to him if that proved true, right? If Hunter Biden is convicted and if Joe Biden continues with his word that if he's in office as president, he would not pardon his own son, then I think that would go, whether people will believe it or not, I don't know. But I think it would be evidence toward him, at least in some ways, not being corrupt, right? At least not just using the presidential office to his own benefit, to his family's own benefit. Now, I'm sure that there's a lot of benefit for all the presidents and their families, right?
What do you mean? Being president of the United States has fringe benefits? I would have never guessed.
Again, you would, just like a juror, you would have to force me to be president. Okay. There are certain things it's just not worth it. But
absolutely not. Are you kidding me?
I don't want any political office. God bless people who even want to.
This is the funniest part. I really did. I went to law school because I wanted to go into politics. You could not. Also, I can't shut my mouth. I realized that was a key component of being a politician. I can yap for days and I have no filter. The sound bites of me that would end up on Fox News would send somebody into a spiral.
Yeah, but from the First Amendment, do we want to get rid of that too? The First Amendment allows you to express those opinions. And allows people to disagree with your opinion and with what we say on the show. Just because we like what we have doesn't mean other people do. And we're all entitled to those opinions.
And I think it's healthy to talk about. That's why I say it all the time. I tell you what my personal opinions are, because I don't think it's bad to talk about. And I don't hate people who feel opposite than me. And I think we can have healthy, productive conversations. I'm going to acknowledge up front, here's how I personally feel about the situation. But legally, this is how I feel. Right. And people can do with that what they will. I think we need a little bit more of that is my hot take is I want to hear the opinions and let's talk about them in a reasonable way.
Yeah. And that's what we're doing is we're talking about the hottest legal topics of the week. So we have hit what we think are the two hottest legal topics, probably talked a little too long, but you can choose to listen or not listen. That's your right too. Join us next week. I'm not sure. I'm hoping that some of these big decisions will be coming out of the Supreme Court, that we can catch up on some of that. Maybe we'll have a decision for Hunter Biden. I don't know how long his trial will be going, but stay tuned with us. In the meantime, don't forget to like and subscribe so you can see the next week's show, catch up on some of our others. Go back through. We've described all of the indictments against Trump. All of them have a different show. Catch up on all of the weeks that we covered the Trump trial week by week. What we thought about Michael Cohen, what we thought about Stormy Daniels. Check up on the legal issues. Don't forget to leave comments. Thank you for everyone who has, and thank you for the reasonableness of the comments. We hope your questions have been answered, and we will catch you next time on the Legal Weekly Wine.